Burglary charges. Are you facing a burglary charge? How do you defend a burglary charge? Is it possible the charge could be dropped? I'm Jeff Hampton with the Fulgham Law Firm. Thanks for joining us today on our YouTube channel. Today I want to go over basically the ins and outs of burglary laws in Texas, go over with you what to expect if you or a loved one is facing this type of charge, and maybe provide you a little bit of an idea of defenses as far as how you can push forward and back against the state of Texas during your defense. Now, if you wait around to the end of this video, I'm also going to give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Okay, now, let's talk about burglary, because under Texas law, it's defined differently depending upon the circumstances, and the statutes are real clear. They make designations about what was taken and what type of either a residence or a building or a vehicle or even a coin-operated machine, what was entered and what was taken. So let's start off. First of all, I want you to understand when you examine all burglary cases, it's all going to come down to two main issues. Did an individual enter a private or whether it's a private building, a public building, a structure, or a habitation with the intent to commit a crime within that structure, but without consent of the owner? So that crime could be theft, it could be assault, it could be other felonies. But basically the two main issues that come up over and over again with a burglary charge is whether it was an unlawful entry, number one, and was there intent to commit a crime when that entry actually took place. So those are the main pieces that have to be proven beyond a reasonable doubt by the state of Texas whenever you examine a burglary charge. So let's first break down burglary charges in Texas based upon their designation. The first one we're going to look at is the burglary of a building. Burglary of a building. That's a non-habitation, just like a store, any type of business or any type of actual location that someone is not residing in, living in that. Now, if an individual unlawfully enters or remains inside a private or a public building that is not a habitation with the intent to commit theft, assault, or other felonies, they can be charged with the state jail felony of burglary of a building. Now, listen, we'll go over what the punishment ranges are and what to be aware of on that end at the end of this video, but I want to just first identify what these charges are. Second one that we're going to look at, second type of burglary, is burglary of a habitation. Now, this is essentially if someone enters into the home of another with the intent to commit theft, assault, or sexual assault, or any other type of felony, then you're looking at a burglary of a habitation. So this is really important because this is what people think of when they get, everyone has that nightmare of thinking, what if somebody breaks into my house? What if somebody comes in here and takes my stuff? Well, there is a difference between burglary of a habitation and a home invasion. A home invasion is where someone actually breaks in, you're there, and they're kind of committing both the offense of burglary and robbery in terms of how they handle you. So we're going to just focus today mainly on the subject of burglary. So a conviction for a burglary of a habitation is a second-degree felony. That's one step below a murder charge. Very serious. So we're going to get into the next one here. We're going to step our way down from a felony burglary down to a misdemeanor burglary, and that is burglary of a vehicle. So if an individual breaks into or remains inside a vehicle with the intent to commit theft, assault, or a felony within, the charge will be a Class A misdemeanor. Now, listen, obviously 99% of the time when someone's breaking into a vehicle, it's to steal somebody's stuff. Now, that's what they're looking to do, is to take something. It's just literally break and grab, right, is what they're looking to do. Well, this is important. Many times we've seen cases where someone didn't actually complete the act. They didn't actually get the item. However, you've seen these people that try to get in with a coat hanger, breaking into somebody's car, or maybe they break the window. If any part of the body or an object, such as a coat hanger, is inserted into the vehicle for this purpose, even though the actual theft element of this may not have taken place, you can still be charged with the crime of burglary of a motor vehicle. Now, also, I will tell you this, burglary, the next one that's a misdemeanor is a burglary of a coin-operated machine. This is rare. I'm not going to spend a whole lot of time on it. But a lot of people don't realize if you actually try to break into a Coke machine, there's people who amazingly know how to do this. They can get in there and steal all the quarters. There's ways, especially the older machines. If you break into a coin-operated machine, it is punishable as a Class A misdemeanor. So let me give you some specific examples of burglary in Texas, just a few ideas instead of being quite so abstract. One of the ways that we look at this is, let's say someone stays past their permitted time in a private or public building, and there's some evidence to establish maybe they had intent to steal something, or maybe they had the intent to maybe assault someone. That can be a burglary. Also, we see this has happened a few times. Someone hides inside a retail store with the intent to commit theft. That's burglary of a building. It's not just theft. That would be considered a burglary. Also, breaking into a coin collection machine to steal money, or using a coat hanger to unlock a car door so that a purse could be stolen. These are all examples of where that can take place, as well as, here's one that kind of happens on occasion, is someone breaks into someone else's RV. That's where they're living, right? That could be technically seen as where someone resides. You're looking at a burglary charge in that situation. So if you're facing any one of these scenarios, it's important to break it down, because let me help you understand, you need an attorney, a good experienced criminal attorney, to provide you a defense to these charges. Because one of the things we find, the first charge I gave you, burglary of a building, that is punishable as a state jail felony, and the range of punishment is up to anywhere between 6 months to 2 years in a state jail facility, and up to a $10,000 fine. Then you start talking about the act of burglary of a habitation. Burglary of a habitation is a second-degree felony, punishable by up to 20 years in prison and up to a $10,000 fine. And then we get to if there was burglary of a habitation with the intent to commit assault, a sexual assault, a more serious felony, you're talking about there, it could be up to a first-degree felony, punishable by up to life in prison and up to a $10,000 fine. Now, I'm just going to take just a moment to give you one possible defense. One of the areas that we find that takes place, especially on burglary charges, whether it's burglary of a building or burglary of a habitation, is what if nothing was taken from the building? What if it becomes a little harder to prove if the individual was in the building, but there's no proof that they were actually trying to take something and there was no one in there? We find that takes place sometimes. If you're not actually taking anything, the state of Texas must prove beyond a reasonable doubt that you had criminal intent. So in that scenario, what happens is, if you had no intent to commit a crime or to steal anything or to assault anyone, and there's no real circumstantial evidence to support that allegation, then you could have a burglary of a building or a burglary of a habitation sometimes drop down to a lesser charge of criminal trespass. And criminal trespass, obviously, you don't want to have to consider any type of allegation or charge against you. But if you're looking at a second-degree felony, burglary of habitation, and it can be dropped down to a Class B misdemeanor of criminal trespass, it makes it worth taking a look at as a way to have leverage to negotiate a case. So that's just one example of a way to potentially mitigate or to minimize a burglary case. So I say all that to say this: if you need help, maybe you have some questions about burglary laws in Texas, maybe you or a loved one is facing a burglary charge in Texas, any one of the ones that I mentioned here, don't hesitate to contact the Fulgham Law Firm at 817-877-3030. We would be happy to go over with you, give you a free case consultation, answer all your questions. And by the way, I promised you, if you waited around, free ebook. Click the link right here below, What to Do If You've Been Charged with a Crime in Texas. We'll send it right over to you. And I hope to see you on our next video series. Thanks for joining us here today on our YouTube channel.